I visited the genocide memorial outside Srebrenica and Potokari, and we were greeted there by the victims, by the so-called mothers of Srebrenica. And I realized really for the first time the importance of the Yugoslavia Tribunal for those victims. There's been more than a reluctance. There's been a denial on the part of the majority of Serbs to admit that their forces and their leaders were responsible for the commission of serious war crimes, let alone genocide. But the peace is held. There are political problems, but I believe that it's possible to conceive that they will be overcome. So I believe deeply that there is a relationship between peace and justice. And if justice is denied, peace can become impossible to achieve. And even if achieved in name, it will not be an enduring peace.
Welcome to the Lawyering Peace interview series, where we explore the art of diplomacy and the legal frameworks that underpin peace processes. In each episode, we engage with diplomats, lawyers, and peace builders who have played key roles in efforts to resolve conflicts around the world through the use of legal frameworks and dialogue. I'm your host, Dr. Paul Williams, the founder and the president of the Public International Law and Policy Group, and the Rebecca Grazier Professor of Law and International Relations at American University. Today, I am joined by my esteemed guest, Justice Richard Goldstone. Richard is a renowned figure in international justice, whose remarkable career began in his home country of South Africa, where he played a pivotal role in investigating apartheid-era violence. His legal reputation and commitment to justice and human rights soon led to his appointment as the first chief prosecutor for the International Criminal Tribunal for the former Yugoslavia, and later the International Criminal Tribunal for Rwanda. Under his early leadership, these tribunals became historic milestones in the pursuit of accountability for war crimes and genocide, setting critical legal precedents and reshaping international criminal law. Throughout his tenure, Justice Goldstone navigated complex challenges, from prosecuting high-profile leaders to establishing new precedents in international accountability. Today, we will dive into his experience at the Yugoslav Tribunal and the legacy of that tribunal, and his reflections on the interplay between justice and durable peace. Richard, thank you for joining us. I'm so looking forward to our conversation.
Well, thank you, Paul, very much for inviting me to do this interview. I am also looking forward to it.
Great. Well, Richard, let's dive right in. We are going to talk in detail today about your role as the first chief prosecutor of the Yugoslav Tribunal. But in order to do justice to that appointment, I want to spend a little time on the legal career that you had in South Africa that led to your appointment. Now, as a Supreme Court judge in the apartheid-era South Africa, you came to be considered one of the few liberal activist judges fighting apartheid from the inside. And as apartheid began to erode in the late 1980s, and South Africa moved towards its first democratic elections, you were appointed as the head of the Commission of Inquiry investigating political violence in the country. Can you give us a snapshot of your role in the transition from apartheid to democracy in South Africa?
Well, Paul, during the last 14 or 15 years of apartheid, the white minority government came under increasing pressure from the international community, and particularly from the United Nations, to abandon its racist policies and to move to a democratic form of government. Sanctions and boycotts were biting, and the economy was suffering. One of the government's responses was to appoint anti-apartheid lawyers to the judiciary and help them portray the independence of South Africa's judiciary. It was independent in the sense that government didn't give any midnight calls to judges telling them what to do or what not to do. their independence was respected. But it should be recognized that politically it could afford to do this because we had a supreme parliament. We had no written constitution. And what judges said one day, the government's majority in parliament, the legislature, could overturn. So it was politically expedient to have the judges move away from apartheid and enable the government to disingenuously deny responsibility for those changes. They could blame the judges. But there were irreversible changes that could be not undone. Let me give you one personal example. In 1981, not long after I'd been appointed as a judge in the Provincial Supreme Court sitting in Johannesburg and Pretoria, I had a case in relation to the so-called Group Areas Act. That was the legislation that enabled South Africa to remain racially apart from a residential point of view. It was a criminal offense for people of the wrong color to live in the wrong area, which meant in effect that black people couldn't live in areas which were designated as being reserved for the white people. But in the dying years of apartheid, I was able to look at that Group Areas Act and in fact to render it nugatory by giving it a valid interpretation. The Act provided that anybody living in the wrong area coming before court could be ordered to leave the area. They could be evicted. And it became a serious criminal offense to be in contempt of a court order of eviction. But it occurred to me in a first case I sat in dealing with that legislation that the power given to the judge was not to make it obligatory to grant the eviction order. It said the judge may do so. And it seemed to me that gave the judge discretion, a judicial discretion, not to evict. And I held, with the concurrence of one of my colleagues at that time, that the effect of this reading of the Act, and it was now 31 years into the life of the legislation, but the first time it had been given this interpretation, I held that the judge could not grant an eviction order, an ejectment order, unless there was an alternative accommodation and all the interests of the parties, and particularly the inhabitants of the premises, were taken into account. Little could I have anticipated that case was the last one in which the Group Areas Act was ever used. Because if they couldn't get eviction orders, there was no point in bringing criminal cases where a person in violation of the law could get, say, a $5 fine, which was the maximum allowed under the Act. So here was an example of where two judges were able to effectively put an end to racial segregation in the residential laws. And within months, tens of thousands of black people were moving into white areas and the government could do nothing about it. The then president was asked in Parliament why the government was allowing thousands of people to move into white areas. And he disingenuously said, "Don't blame the government, you can blame Judge Goldstone." Well, that was disingenuous because the government could have, in fact, overturned the law and amended one word. There were other similar cases, and that really began the unraveling of many of the apartheid laws. Then, in the dying years of apartheid, I was appointed by the government to investigate a couple of contentious cases involving the police and misconduct, serious misconduct by the police. And in both cases, in the most important of those cases, I held against the police. As a consequence, the victims of violence were paid handsome compensation by the government. The violence really broke out after the release of Nelson Mandela from prison. It was unexpected, but during the transitional negotiations, which began in 1990, there was increasing violence. And Nelson Mandela's thesis, which he put forward very eloquently, was that the violence was the cause, was what he referred to as a third force. The third force were government supporters in the police and the army who were doing what they could to foment and stoke violence in the black community in order to avoid the ending of apartheid. So I was appointed to head a commission on political violence and intimidation. That lasted for over 2 years, during which I held over 40 discrete investigations. But the most important was that into the allegation of a third force. And to cut a long story short, we were able to execute a raid into government offices, into the military intelligence, and we found written evidence that, in fact, the military were fomenting the violence. And that hastened the transition. It really made it inevitable that there was going to be majority rule. And a transition which then President de Klerk envisaged would last maybe 10, maybe 15 years, in fact, only took 4 short years. And as we all know, the apartheid system came to an end with our first democratic elections and the appointment of Nelson Mandela as the first democratically elected leader of South Africa. One point I should make is that the commission that I headed achieved a lot of international recognition, and particularly in the United States. The media, and particularly the New York Times, had a number of articles explaining what we were doing in investigating the violence. And in some of the worst years of the violence, the then Secretary General of the United Nations, Boutros Ghali, appointed Cyrus Vance, the then former Secretary of State, to be his representative in trying to get the negotiations on track again. They had really gone off the rails. And I became friendly with Cy Vance. I've informed him fully of what we were doing on my commission. And he reported back to the Security Council of the United Nations in a very well-publicized report in which he really paid attention to the work of the Commission. And that gave it very important further international recognition, which made it literally impossible for the government to ignore us and to refuse requests that we were making for more powers in our work. So that, Paul, is generally the background of my involvement at that time, and which led to this international recognition.
Well, Richard, that's very telling in terms of the ability of a small number of judges, lawyers, to make an impactful difference, which is exactly what happened with the Yugoslav Tribunal. And we can pivot now into a bit of a conversation, but I get the sense it's a little bit deja vu with Yugoslavia Tribunal, where you showed up and immediately began having an impact on the prosecution of atrocity crimes. Let's spend a few moments, if you can, for our listeners. How did the Yugoslav Tribunal come about? All of a sudden, there's an international criminal tribunal for prosecuting atrocity crimes in Yugoslavia. We haven't had tribunals since Nuremberg and Tokyo. What happened? How did this tribunal come into being?
Well, the context is important, Paul. The post-World War II Yugoslavia was a federation of 6 ethnic states that were held together by the force of the personality of Josip Broz Tito, as he liked to be called, Marshal Tito. In the late 1980s, after the death of Tito, Yugoslavia began to break up. It took almost a decade, but in June of 1991, 2 of the states of the Federation of Yugoslavia, Slovenia and Croatia, declared their independence. Serbia was ruled really under the autocratic leadership of Slobodan Milosevic, and ostensibly to protect the interests of ethnic Serbs in Slovenia and Croatia, Milosevic began military offensives in those 2 provinces. What became the former Yugoslavia descended into a vicious war. In April 1992, Bosnia and Herzegovina declared independence, and the war there captured the world's attention. Serbia, still led by Milosevic, fought a vicious war, particularly in the areas of Croatia and Bosnia, where there were significant numbers of ethnic Serbs. In May of 1992, Milosevic withdrew his army from Bosnia and relied on the fiction that the war in Bosnia was a civil war. In fact, he was resourcing that war and egging on the people that really he was responsible for appointing, the Serb commander Ratko Mladic and the self-styled president Radovan Karadzic. They were the de facto military commanders, and as I say, were a source from Belgrade. They took control of most of Bosnia and drove millions of Muslims from their homes. Thousands were kept in concentration camps. And soon stories multiplied in the media of murder, torture, and sexual violence against the Muslim victims. The United Nations was really driven by public demand to take action. The Western powers, not unusually, were not prepared to put boots on the ground, and the rather minimalist action that was taken by the Security Council was to establish the first war crimes tribunal since the Nuremberg trials almost half a century earlier. It was especially established by the Security Council as a peacekeeping tool. So that really is the background to setting up the tribunal. Many people assume it was set up to fail, and it was in that difficult atmosphere that I unexpectedly, really as a bolt from the blue, became involved.
Well, Richard, you talk about your nomination, your selection being a bolt from the blue. Can you walk us through that? How did you end up becoming the first international criminal prosecutor in our lifetimes?
Well, again, it's an interesting story, but the Security Council decided that it, together in conjunction with the General Assembly, would elect the first 11 judges of the tribunal. And they did that in September, October of 1993. The tribunal was set up in May 1993, and it took them 5 or 6 months to get nominations from the various members of the United Nations and to appoint the judges. But the Security Council, interestingly, decided that the position of chief prosecutor was so politically fraught that the Security Council would appoint the prosecutor. And it decided not only that it would appoint the prosecutor, but that it decided that it would do so by consensus, which meant that all 15 members of the Security Council had to agree to the appointment of the prosecutor. So there were not 5 vetoes. In effect, there were 15 vetoes. And it didn't take long, however, before it elected the first prosecutor. The nominees had to be submitted by the Secretary General. Boutros-Ghali, towards the end of 1993, nominated the then Attorney General of Venezuela, Escobar Salom, and he was appointed unanimously by the Security Council. He asked for a postponement of his coming to The Hague because he was busy prosecuting the former president for fraud. Eventually, in January of 1994, he arrived in The Hague, and he was there for only 3 days before he resigned to take up the position of Deputy Prime Minister of Venezuela. So the Security Council was back to square one and had to begin again the whole process of appointing a chief prosecutor. I should mention that one of the things Escobar Salom did during his 3 days in The Hague was very important to appoint a deputy prosecutor in the person of Graham Blewett, a very experienced Australian prosecutor who was very important in those early years of the tribunal. But I'll come back to that. Between January and June of 1994, 8 nominees of the Secretary General were vetoed by one or other member of the Security Council. 5 of them had come from NATO countries, and the Russian Federation vetoed them. The United States nominated an Egyptian-American, Sharif Bassioni, who was really one of the world's experts in international law, but he was vetoed by the United Kingdom because he was a Muslim. And the United Kingdom felt it wasn't politic to have a Muslim chief prosecutor when it was known that most of the victims were in fact Muslims from Bosnia and Herzegovina. One of the non-permanent members of the Security Council was Pakistan, and you'd hardly say how aggravated and infuriated the Pakistanis were that a Muslim had been vetoed by the United Kingdom. And when the UK nominated somebody from Scotland, Pakistan vetoed in retaliation for the UK vetoing a Muslim. The circus went on right into June and into beginning of July of 1994. The judges, as I mentioned, had been appointed already in September, October of 1993, and they were angry and frustrated that no work was being prepared for them in the absence of a chief prosecutor. And it was in that context that in June of 1994, soon after the election of President Mandela as president of South Africa, that it was suggested to the president of the tribunal, Antonio Cassese of Italy, and to Boutros-Ghali, that if they could find a South African who had the support of Mandela, the Security Council would not, in June, July of 1994, veto such a person from South Africa. So that was how it happened. I didn't know this background at all. I'd followed, not very closely, the short history of the Yugoslavia Tribunal, but at the end of my investigations into violence, my wife and I went for a well-earned holiday. On my first day back in my chambers at the then highest court, the Supreme Court of Appeal, as it's now called, I found a fax from President Cassese asking me whether I was interested in becoming the chief prosecutor of the Yugoslavia Tribunal. Well, the short answer was that I wasn't interested. In the first place, I'd been told that week that President Mandela wanted me to be one of the first 11 judges of our new constitutional court, which was a dream appointment, and there was nothing I was prepared to do to avoid that from taking place. But in addition, I was really not qualified for the position for three reasons. Firstly, I'd never been a prosecutor. That alone disqualified me. Secondly, I knew nothing about international humanitarian law, the law that the tribunal would be applying. And thirdly, I knew next to nothing about the former Yugoslavia. So I was on the point of sending a polite refusal to President Cassese when I had a phone call from President Mandela. And he said he understood that I'd been invited to take this position, and I said yes, but I was on the point of refusing. He asked me why. I gave him the reasons I've just set out. And he said, I understand your problems, but he said the United Nations did so much in bringing apartheid to an end. He said, I felt that we cannot refuse this request for a South African to take up the first really high position in the United Nations system since the end of apartheid. He said, don't worry about the Constitutional Court. He said the Cabinet decided today that we would amend the Constitution to make it possible to appoint an acting judge, and I will tell the Secretary General that you will only come for 2 years and then come back to the court. So please don't send your letter. He said it would be very embarrassing because I've told the Secretary General that you will do it. So that was really the end of any option I had to refuse the position. So that's really, I think it's a good example. I always like giving students this example of how international humanitarian law is all about politics. And the Security Council was really prepared to forget about the need of the victims for justice to be given them, and that these games on the Security Council were really played at the cost of the victims of terrible war crimes that were committed in the former Yugoslavia.
You had already been accepted. President Mandela had already accepted on your behalf. Let's pivot a little bit to your first few days, your first few weeks at the tribunal. You show up. There's judges who've been there for many months. There's Graham Blewett, your deputy, but you essentially had to build an office of the prosecutor from scratch. I remember the building was an old insurance building that the Dutch had made available for the tribunal. But walk us through a little bit of the bureaucratic, logistic, legal hurdles you faced and how you overcame them.
Well, Paul, the biggest hurdle was in fact the parlous state of UN funding that was available for us, and also its difficult bureaucracy. We needed urgently to set up the Office of the Prosecutor and to staff it with competent experts from around the world. The staff had to have adequate geographic and gender balance for the United Nations office. And when I arrived in The Hague in the middle of August of 1994, there was a skeleton staff of about 40 people, and importantly, this highly competent deputy prosecutor, Graham Blewett. The United States had generously sent 22 highly qualified people to The Hague. Of the first 40 people who I found there, 22 came from the United States. Experienced prosecutors, computer experts, investigators, and they were essential in the early days of the Office of the Prosecutor. It was really the work of Madeleine Albright, who was then the United States permanent representative at the United Nations, and her counsel, David Sheffer, who were responsible for early, tremendously important support for the Yugoslavia Tribunal, and particularly for the office of the prosecutor. But the first serious problem I had on arriving in The Hague was that the United Nations was threatening to withdraw the 22 people sent by the United States if the United States wasn't prepared to pay immediately in cash 13% of the cost to them of sending those 22 people. This sounded like a crazy request, but in fact, this is an arcane law in the United Nations that any member of the United Nations giving a gift to the organization had to put up 13%, had to pay 13% in cash of the cost of the gift. The reason for that actually is quite an understandable one. It was to avoid members of the United Nations choosing programs of the United Nations that had not been budgeted for. And obviously sending 22 highly qualified people meant that they had to be given offices, they had to be given computers, they had to be given secretarial support. In the case of the investigators, they had to be given travel. So that was the background to it. And the United States, on the other hand, not strangely, was simply not prepared to pay the 13%. The attitude of the US government was we very generously paying a large amount to send you 22 American experts. We're not going to, in addition, pay the 13%. Well, the United Nations said, in that case, we're not going to give them their office equipment. We're not going to give them travel assistance, and they will have to come back to the United States. Within my first week, I had to pay an urgent visit to the United Nations headquarters in New York. And after much cajoling of their financial heads of the UN, I got them to agree to suspend the demand of 13% for 1 year. Jumping forward, they did the same thing in the second year. After I left the tribunal, and my successor was Louise Arbour of Canada, she wasn't as fortunate as I was, and the United States had to, in fact, agree to the withdrawal of most of the Americans who'd been sent. Some of them were put onto the permanent staff of the tribunal, so not all of them were lost, but this gives you an idea of the financial problems that there were from the very beginning. I might add that in July, after my appointment by the Security Council, the Secretary General asked me to visit him in New York and to be briefed on the tribunal and the role of the prosecutor. And I was told that I should book my own air ticket to the United States, and I would be reimbursed when I arrived at the United Nations head office. Well, in good faith, I booked my ticket. They told me to book business class. And when I arrived in New York, I was told by a rather embarrassed head of the legal office, who was then recently appointed, Hans Corell, that in fact the United Nations didn't have money in the budget to pay my airfare, and he hoped by the time I got to The Hague in the following week, the money would be available. But that gives you the level at which the financial problems of the United Nations impacted on setting up the office. And you can imagine we needed to employ numbers certainly we were looking at over 100 members of staff, and they didn't have the money to pay the chief prosecutor for coming from South Africa. So it was very difficult. The media played a big role in ensuring that the Security Council found adequate funding for the tribunal, but that took many months of hard work in the opening weeks and months of the life of the tribunal.
Well, Richard, you mentioned that when the tribunal was created, some people anticipated or thought maybe that the tribunal was set up to fail or created to fail. Others were very anxious that this was going to be a legal mechanism operating in a highly political environment. Can you walk us through some of those earlier perceptions of the tribunal? And within that context, how did you craft your prosecutorial approach when you sat down on that first day and thought, right, I need a prosecution strategy? What was going through your mind, and what was your subsequent strategy?
Well, if I could first deal with the importance of getting civil society support. and media support for the tribunal. It appeared to me, and that was really with my experience in South Africa, I learned of the importance in setting up these mechanisms, that there had to be support from the ground up. And that was important. From the beginning, I had close relationships with the media in The Hague and in New York and Washington, D.C., and in important European capitals, and particularly with civil society organizations, both international and domestic. With regard to prosecutions, we realized pretty much from the first day that we didn't have a paper trail that was so cardinal and critical in mounting the prosecutions against the Nazi leaders in Nuremberg. We had to go the route of circumstantial evidence. We needed to prove that there was a pattern to the ethnic cleansing by the Serb and Bosnian Serb armies of villages in which there was a meaningful presence of Bosnian Serbs and Croatian Serbs in the case of Croatia. An important development was the assistance that I received from the United States intelligence community. We made requests immediately at the level of the State Department and the intelligence community, and again, Madeleine Albright and David Shepard played a key role. They introduced me to the leaders of the intelligence community, particularly the Central Intelligence Agency and the Department of Justice. And we got, unusually at that time, and at all times, I think, the intelligence community in the United States don't like sharing confidential information with American prosecutors. Even less would they want to do that with an international prosecutor. But they were prepared to do it. There were a number of conditions. We had to arrange for appropriate undertakings to be given to protect the sort of intelligence information we were given. We had to set up a special safe room at the tribunal offices in The Hague. And in the case of many really secret documents, we had to only access them at the United States Embassy in The Hague. But it was important that we got that information. And I recall vividly the first briefing we were given at the CIA. I took Graham Blewett with me, and we had to limit this information to very few vetted members of the prosecutor's office. But I remember being briefed, and there was a large map of Bosnia on the wall, and we were shown, this was sort of been certainly during, towards the end of 1994, beginning of 1995, we were shown on the map a swathe of villages that bordered on Serbia, where ethnic cleansing had taken place. And there was a similarity of action that was taken. Mosques were destroyed, the homes of Muslims were destroyed, the attacks were made on the Muslim population and not on the Serb inhabitants. And it was clear that there was a pattern. We added to that the boasts that had been made by Radovan Karadzic, the self-proclaimed president of the Serb enclave in Bosnia, his boast, which he made on television and to journalists, that nothing happened in his army, of which he was the supreme commander, nothing happened in his army which he didn't know about. Well, we realized if we could establish this pattern, it would lead to a prosecution of Karadzic and Mladic. And we started gathering indictments against the Bosnian leaders who committed serious war crimes in those villages. And when we had enough of them, we were able, by July of 1994, less than a year after I arrived in The Hague, we were able to issue the first indictment against Karadzic and Mladic of serious war crimes. They were followed up not long after with indictments for the commission of genocide in Srebrenica. So this was really where we were coming from. We were criticized in the beginning for going after small fish in these villages to which I referred, but we really had no option but to build cases from the ground up. And of course that worked, and it ended up getting Milosevic into the box as well. Unfortunately, it took some 13 years to get them into the dock in The Hague. That was because they went into hiding, and they were really protected. They were really protected by the failure of the United Nations and later the NATO forces to arrest them at times when they could have arrested.
Richard, did your indictment of Ratko Mladic and Radovan Karadzic surprise the international community? You'd been a prosecutor for less than a year, and all of a sudden you're indicting the general of the Republika Srpska, the self-proclaimed president, or the president of the self-proclaimed Republika Srpska. What did the diplomats think about this? We'll talk about Dayton in the next question, but what was the initial reaction from those who had created or sponsored the creation of the tribunal? Were they taken aback, or they're like, yes, this is exactly what we need to bring peace to Yugoslavia?
Well, certainly, I think they were surprised, and a lot of them were not very happy about it, including, let me say, the Secretary General. A couple of days after I announced publicly the indictment of Karadzic and Mladic, I was summoned urgently to the Secretary General's office in New York. And he was in one of his bad moods. He was a very mercurial figure, Butrascali. But he was very annoyed, and he said to me, how dare you issue an indictment against Karadzic and Mladic without consulting me? And I said, the Secretary General, under the Security Council resolution appointing me, I'm expressly forbidden to take any orders or to be influenced by any other person outside the office. And I said, that must include you. He said, well, I accept that, but he said, this is the difficulty I have. I don't know how to deal with somebody in my organization who doesn't have to accept my instruction. And I said to him, Secretary General, if I had consulted you, you'd have told me not to issue the indictment. He said, absolutely. I said, well, in that case, I'm very happy that I didn't consult you. And we left it on that sort of unhappy note. His argument was that there had to be peace negotiations. The war was still raging. There had to be peace negotiations, and the indictment of Karadzic would negative any hope of reaching an agreement. We were also, for similar reasons, refused effective cooperation by the then United Nations forces in Bosnia. They had been sent there as a peacekeeping operation by the Security Council, and by the time these indictments were issued, the United States was involved in sending members of the peacekeeping term. And in fact, the United States Admiral then was in charge of the United Nations forces. And they refused to arrest Karadzic or Mladic or other people who were indicted by the tribunal. And the rather weak excuse they gave, this was the military, they said, we're not police officers, we're military, and it's not our job to arrest people. And they allowed some of these people, including Karadzic and Mladic, to brazenly go through roadblocks manned by the United Nations forces and not arrest them. Well, that came as a huge shock to me. I couldn't imagine for a moment before it happened that the United Nations forces would refuse to implement an arrest warrant issued by a prosecutor who was appointed by the Security Council to do exactly that, to issue those indictments. I remember discussing it with the then Secretary of Defense in Washington, D.C., Bill Perry. Bill Perry was very open and very transparent. He said, I agree with you. He said, there's no question that these people should be arrested by the UN troops. But he said, your problem is that the chiefs of staff don't agree. The chiefs of staffs in Washington are not prepared to put the lives of United States troops at risk by arresting the most popular leaders of the Bosnian Serbs. And he said, President Clinton has been informed by the chiefs of staff that they don't want this to happen. And he said, quite frankly, Bill Perry said, quite frankly, the President Clinton isn't going to disagree and go against the wishes of the Joint Chiefs. So that's a short answer to your question, Paul. There was not only disdain on the part of some of the leaders, and these were the countries that supported the tribunal, but that was the reality of the situation that we were faced with.
Richard, let's take that conversation a little deeper. You indicted Karadzic and Mladic in July of '94, at the time that Dick Holbrooke and Carl Bildt were doing shuttle diplomacy to tee up the Dayton negotiations. Your indictment of those two individuals essentially excluded them from attending Dayton. How do you see that relationship? Did your indictment, the tribunal's indictment of Karadzic and Mladic contribute to peace, to building a durable peace? Did it potentially undermine the Dayton Accords? Did you think about it? Walk us through that time.
Well, Paul, we couldn't have anticipated the meeting of Dayton. And obviously, Boutros-Ghali himself didn't anticipate the meeting of Dayton, where the end of the war was agreed. That was happenstance. But of course, the important aspect is that the meeting at Dayton couldn't have happened without the indictments of Karadzic and Mladic, Karadzic in particular. By the time Dayton was held in 1995, the Bosnian leaders would have been in the same room. There's no way they would have met with Karadzic had he been at Dayton. But because he'd been indicted and was subject to an arrest warrant, Karadzic couldn't attend at Dayton. The United States would have arrested him and sent him for trial in The Hague. So with hindsight, it was ironic that Milosevic was appointed by Karadzic to represent the Bosnian Serbs at Dayton. And as a result, the meeting could take place without Karadzic being there. So in fact, it's the only vivid example I know of justice assisting peace. Without the indictment issued by a war crimes tribunal, the meeting at Dayton wouldn't have happened, and the war wouldn't have come to an end when it did in the middle of 1995.
So, Richard, let's pull back to 10,000 feet and look at this question of the interplay between peace and justice. You mentioned this is one of the only instances that come to mind about how justice directly promoted the achievement of peace. What is your overall perspective on the interplay between peace and justice?
Well, Paul, let me say, I've never believed that there can really be a durable peace without justice. You can get forms of a peace, but they're not going to last without justice. And I'd include truth commissions in that regard. I don't believe that there would have been a lasting peace in South Africa, and we've had difficulties since democracy came, but we remained a democracy, and there has been relative peace in South Africa ever since. I don't believe that would have happened without the Truth Commission. I think the Truth and Reconciliation Commission that was headed by Archbishop Desmond Tutu made a huge difference because it gave recognition to the victims of what they'd gone through. And that was important. In the case of the former Yugoslavia, it's a bit more complex because they're all people of different religions in particular involved, and even though they share a language and they share a history, there are these religious problems and politicians who prepare to use them to avoid any enduring peace. But I know from my own experience in the early 2000s, I paid a visit to the former Yugoslavia. I was then teaching at the Central European University, which was then in Budapest. And the then president was John Shattuck, who had been the Assistant Secretary of State for one of the Assistant Secretaries of State in the US government. At the time, I was the Chief Prosecutor, and he was particularly helpful with regard to setting up the Rwanda Tribunal. But John Shattuck, when I was teaching at the CEU in Budapest, suggested that he and I should pay a visit together to the former Yugoslavia, and that he and I should give talks in Belgrade and Zagreb and Sarajevo about peace and justice. And we did that. And we were greeted by a lot of antagonism in Belgrade, less antagonism in Zagreb, and absolute friendship in Bosnia. For the majority, and particularly the Muslims in Bosnia and Herzegovina, the War Crimes Tribunal was regarded as very important to them. And John Shattuck and I visited the genocide memorial outside Srebrenica and Prosecutorial, and we were greeted there with a lot of tears and hugs and embracing by the victims, by the so-called mothers of Srebrenica. And I realized really for the first time and saw with my own eyes the importance of the Yugoslavia Tribunal for those victims. So it makes a difference. And I think this really cannot be exaggerated. I wish I could be more optimistic in this area. There's been a reluctance, more than a reluctance, there's been a denial on the part of the majority of Serbs to admit that their forces and their leaders were responsible for the commission of serious war crimes, let alone genocide. But the peace has held. The war that came to an end in 1995 has remained a peace. There are political problems, but I believe that it's possible to conceive that they will be overcome. So I believe deeply that there is a relationship between peace and justice. And if justice is denied, peace can become impossible to achieve. And even if achieved in name, it will not be an enduring peace.
And Richard, do you see this perspective taking hold among the international peace-building community? And we now have an international criminal court. We've had a plethora of other courts. There's development of hybrid mechanisms. When you step back and you look at what you played a key role in starting with, the Yugoslav Tribunal and a high-level and high-profile indictments that impacted the peace process, do you have the sense that the diplomats, the mediators, the negotiators have come to embrace the role of justice in building a durable peace? Or do they generally have buyer's remorse and wonder what they created?
Well, the truth is somewhere in the middle, I would suggest. Without the Yugoslavia and Rwanda tribunals, the two ad hoc tribunals established by the Security Council in 1993 and 1994, respectively, and soon thereafter the Special Court for Sierra Leone, headed by David Crane. Without those three tribunals, we would certainly not have an international criminal court up and running today. The successes, and they were seen as successful by the international community, broadly speaking. And we wouldn't have had, in 1998, the diplomatic conference in Rome called by the then Secretary General, Kofi Annan. We wouldn't have had that meeting. And we wouldn't have had 120 countries voting in favor of setting up the International Criminal Court. It's of course regrettable that some powerful and important countries, including the United States, have not joined the Rome Treaty, but we have now 124 members of the treaty, and the court does work. That wouldn't have happened without the history of the ad hoc tribunals and the Sierra Leone Tribunal and the Cambodia Tribunal. So we have advanced not as quickly as I would have hoped, but that's the politics. The politics makes it very difficult. But it's really a question of taking 3 steps forward and 2 steps back. The movement is a forward movement. And I believe that the International Criminal Court, notwithstanding all of the political problems it's always gone through, and it's going through particularly today, and the election of President Trump is going to make it all the more difficult. We know the action that his administration took against the International Criminal Court during his last administration, and I think one can anticipate that happening again. But there's sufficient support, I believe, in the international community in Europe, in Asia, and particularly in Africa, for the International Criminal Court, that we're not going to see the end of it in the years coming.
And do you have a sense that the diplomats the negotiators have developed an accommodating relationship with justice as they pursue peace negotiations?
I think it's difficult to generalize. I think in Europe there's very strong support for international justice. And in fact, the newly appointed Attorney General of of England and Wales, Richard Hermer, has recently given a very strong support to the rule of law, not only domestically, but also internationally. I think that support in the majority of European countries is going to continue. In Africa, there's growing support for international justice. The attitude of the African Union, which was against the International Criminal Court not too many years ago, has changed. And there now is generally strong support on the African continent for the court. So I remain optimistic for the future of international justice. I have no doubt that if there was an International Criminal Court up and running today, there would be a strong movement to set one up.
Oh, that's encouraging to hear. I'm always trying to work with my students to help create a perspective of the role that justice plays in building a durable peace and teeing them up to convince future diplomats that it's necessary. Richard, let's talk a little bit about the progress and the success that you and your team made in terms of gender-based crimes. The tribunal is rightfully heralded as having brought in a new era of international law surrounding the prosecution of gender-based crimes. Can you walk us through how that became a central focus of your prosecutorial strategy, and why was it so successful?
Well, the beginning of that story is that when I took office as chief prosecutor, there was really hardly any recognition of gender-related crimes in international humanitarian law. Really, the only reference was in the definition of crimes against humanity. And that wasn't easy. That wasn't easy to prove, especially in the beginning of the life of the tribunal. But then there was huge push, particularly from civil society and from women's organizations in the United States and Europe in particular, but also later from Africa in the light of the serious allegations made in the Rwanda tribunal. There was a huge push to give recognition to gender-related crime. I didn't need any arm twisting in that regard, and we decided to go for it. And I appointed Patricia Sellers, who was a leading light in those days. Patty was then working for the European Union, and she was already at The Hague when I arrived. And I appointed her to be in charge of gender issues, not only in respect of war crimes, but also in our office. It was very important, it seemed to me, if we were going to get this right, that we couldn't allow any gender discrimination of any sort in our office. And Patty Sellers was working really with my full and active support, and I think that made a difference. And there was evidence pouring in of gender-related crimes of rape, both in the former Yugoslavia in particular, much less so in Rwanda. But we decided very soon after I began in The Hague that we would put together as a symbolic gesture, we would put together an indictment that dealt only with gender-related crimes, with rape and other forms of sexual violence as the core of that indictment, the so-called FOTCHA indictment, and that resulted in an important success in the Yugoslavia tribunal. But the result was, and of course I should not leave out of account the important evidence of gender crimes that were reported in the Bassioni report, which preceded the establishment of the Yugoslavia tribunal. So there were reports coming, particularly out of the refugee community in Germany, of terrible gender-related crimes that were being committed. So we gave special attention to it and really put it on the top of our priority list. And that worked, because it resulted in the Rwanda tribunal holding that systematic mass rape could be a form of genocide, and that was an important breakthrough. And I don't believe today, if one looks at the Rome Treaty of 1998, we see very wholesome definitions of gender-related crime, which was completely absent before the 1998 Rome Statute. And that was a result of the work of the ad hoc tribunals, but importantly, and I can't emphasize it enough, the work of civil society and women's organizations who pushed so hard to get adequate recognition for gender-related crime.
Well, Richard, just as the penultimate question, were there other areas of international law in the gender space or in other dimensions that in those first 2 years you developed, you pushed the envelope, you helped to clarify?
Well, it may seem strange looking back, but my own belief is really the single most important success of the Yugoslavia and Rwanda tribunals was that they proved that international tribunals could hold fair trials and efficient trials. That wasn't a given. When we were set up, there were many serious lawyers who said, you're never going to have proper trials before this international court. You've got judges coming from the common law and from the civil law and all sorts of systems. You've got investigators and prosecutors coming from around the world. they're simply not going to be able to cooperate and put on fair and efficient trials. So that was also part of the atmosphere which we came into. But I don't believe that after the first trials were held in The Hague and later in Arusha, that there were any serious allegations about the unfairness of the trials. In the beginning, it was absolutely apparent to me that if the first trials were not fair, were not seen to be fair by the international community, broadly speaking, if they were not seen to be fair, that would have been the end. That would have been the end of the tribunals. So I think that was an important first success of the two ad hoc tribunals.
Richard, for our last question, what is the key takeaway you want our listeners to remember? Many of our listeners are young professionals, mid-career professionals who either are embarking on or transitioning into the field of international criminal law or peace negotiations, doing mediation or representing parties. What is the one or maybe two things you want them to take away from this conversation about the interplay between justice and building a durable peace?
Well, the first thing, Paul, I would do is point to the successes of the tribunals, and particularly the advance that they have resulted in international humanitarian law. Now, if the law isn't used, it wilts. And international humanitarian law hadn't really been used for almost 50 years after Nuremberg. And the result of their being used in the war crimes tribunals, both those set up by the Security Council and those set up by the General Assembly, the result has been that the law has been used and it's advanced. It's advanced in very important areas. And I think that's an important endeavor. And again, it's the victims of these terrible crimes who must be given first place in the hearts and minds of anyone wanting to get involved with international humanitarian law. And I would say to young professionals and to students that if you want an interesting experience, get some work in one of the international criminal tribunals. There are not that many left because of the International Criminal Court really appropriately coming into its own. But it's a fascinating area of the law. There's wonderful camaraderie. People come together from different systems. And one of the things we all learned was that all systems of justice, from the north and the south and the east and the west, all of them have one thing in common. And that is the establishment of the truth and the implementation of the law. So I would encourage people to get involved in what is a fascinating area. And I'm sure people who have worked in the prosecutor's office or the judge's chambers or in the registry of these courts will agree with me in saying it's a fascinating area of the law to become involved with.
Well, Richard, I wanted to thank you for taking the time to share your thoughts and your insights on the interplay between peace and justice. You've been very generous with your time this last hour. I also just want to say personally, it's been a real honor and privilege to have this conversation with you and to be friends over the last 3 decades. I have to say, whenever I teach international criminal law or peace with justice in my course, every single student knows you. They don't know my references to to Gilligan's Island and 1980s TV shows that I use in class. They all know Justice Richard Goldstone, both from your work, your anti-apartheid work in South Africa, and your work as the first prosecutor kicking off this whole industry, so to speak, of international criminal law that they want to be a part of. So thank you for your friendship. Thank you for your time. And thank you for all that you've done, both for international criminal law, but also to inspire the next generation of those seeking just and durable peace.
And thank you, Paul, very much for your generous remark. But thank you above all for taking these endeavors further in the important work that you have done and continue to do. We can all be grateful to you for that.